Hello and welcome to our Podcast Plus, bringing you insight for best practice in bite-sized chunks. Today we're talking about preparing for a Lexcel assessment during the COVID-19 national emergency. Let me introduce us. My name's Neil Partridge. I'm the Operations Director at PDA Legal and a long-time Lexcel assessor. I'm joined today by Samantha Aldridge, who is a Director at P&P Hub and until very recently was the Head of Compliance and HR at a very successful law firm. One of her roles there was to manage the day-to-day process of preparation for Lexcel assessments. Samantha's been through this many times before. Our contact details are here. Please do get in touch with us if you have any questions or concerns following today's podcast. So what I'd like to do now is hand over to Samantha, who will talk us through what we're going to cover in the next 15 minutes or so.
Thank you, Neil. So on the slide shortly, there's going to be a list of items that hopefully we'll cover today. If you've listened to any of our other podcasts, you'll notice that this is a slightly different approach. It's a bit more Q&A style, but I'm asking these questions as somebody who's managed an assessment. So these are the things that I would want to know, and I'm hoping it addresses some of the concerns that you may have. So firstly and importantly, Neil, our assessment is COVID-19 lockdown, and broadly speaking, what confirms expect through the assessment?
Okay, so in a nutshell, yes, they are going ahead. The Law Society has made clear that every Lexcel accredited organisation will have a Lexcel assessment in 2020, but there's an enormous degree of flexibility with that. The Law Society has worked very hard with the assessment units and with the assessors to put some fluidity into this, to take into account the extraordinary circumstances. But essentially the approach to this would be that each individual assessment is being considered on its own merits. The Law Society is encouraging firms and departments to speak with their assessors first. So the assessor they've been very well briefed as to how to approach this. And it falls down into two general categories. One is you can have a remotely conducted assessment on or around about the anniversary month of your Lexcel accreditation. I've done a few of these and they've been done very successfully. It's actually worked out remarkably well. And I think we'll provide some more insight in that in a moment. What I would say is, no matter which way you go with this, the other aspect that's being considered, especially with things like furloughing involved, is the Law Society has recognised that the scoping may change a little bit. Firms with furloughed staff may reduce their scope a little bit. So what are the changes you may experience here? You may find that the assessor's looking at a smaller scope of people this year. The way we conduct interviews, if it's not on site, it's going to be by telephone or it's going to be by video conferencing. And perusal of documents is being approached flexibly as well. So this is very much a situation where we are looking at things on an individual case-by-case basis so that firms are not disadvantaged.
Thank you. So in terms of the assessment days, what changes are there to the review of central records? How will that work?
Okay, well, there are two types of central records. There's the type of central record, the office manual, or the official title for this is the Register of Plans, Policies and Procedures. That will be reviewed as it always have been. There is nothing different about that. So in advance, the assessor will contact the firm. I normally see the central documents, the office manual and one or two others, 3 to 4 weeks before I come on site, sometimes a bit more, sometimes a bit less. There's also some documents centrally that, of course, we usually see on site, things like the central record or register of file reviews, perhaps the register of counsel and experts, perhaps the register of personal data processed by the practice or department, perhaps the training files, the sort of thing we see on site. Where those are present and they're available normally on site and can't be provided in advance, what we're doing is we're saying, fine, somebody senior, maybe the practice manager, somebody who has access to all of these, would just have them on their computer, and through screen sharing, the assessor would say, okay, please can you show me the risk register? And the risk register would be brought up on the screen by the person at the other end. And I've actually recorded a couple of areas of good practice where this has happened, because I've spotted things on a risk register or a register of personal data. And I've had the opportunity, because we're screen sharing live, to say to the individual, okay, can you talk me through this particular aspect? And it's uncovered some really good things. What I would say is this is obviously additional to what we normally do on site, where we look at central documents on our own. And the person who is going to show us these documents needs to set aside an hour or so to do that. But again, that's just something that the assessor will plan with you in advance. And all of these documents you're always informed about the documents that need to be seen by the assessor during the assessment planning process. So there's no shocks, no surprises. And if there's any of these documents that you think you might struggle to provide the assessor with, talk this through with the assessor in advance when the assessment plan is drawn up.
Thank you. Yes, my next question was just going to address that last point that you mentioned. So if some documents are held electronically and some are hard copy, they may not be accessible.
What we're going to do there is, as we've always done, is provide the assessment plan in advance. Normally I send the assessment plan out 2 or 3 weeks beforehand. At the moment, we're having conversations. We're planning assessments 3-4 months ahead, like we've always done. And we're talking about them with the firms and departments. Then, at that point, we would say to practices, are there any documents that may be a bit sticky to get hold of and the ones in paper? We talk about this weeks, if not months in advance, and we say to practices, okay, if you've got them on paper, could you possibly scan them? Don't send them to us, but scan them, have them on your computers, and we'll share them with you when we screen share. In fairness, 90% of such documents are done on Excel or Word anyway, so electronic copies are usually available. But if it's discovered in advance that, guess what guys, unfortunately, this particular document we just can't get hold of, we'll discuss that with the assessor. But having 1 or 2 documents unavailable, discuss it with the assessor. If necessary, the assessor will discuss it with the assessment unit or with the Law Society, and the Law Society will make a decision about how to play it. But there is this flexible vehicle as to how to approach this for this particular year.
Thank you. So staff interviews will be conducted over video conference. I imagine they'll be able to share documents with you, show them on the screen. Will that mean that the interviews are slightly longer, and how will they work?
Okay, well, you're right. The interviews will be slightly longer. Typically, we allow separate time for looking at on-site for perusal of matter files, and then separate time for an interview where if it's fee earners, we talk about what we've seen on the matter files, and then we talk about procedural questions such as, have you had an appraisal this year, or how is your supervision working, things like that. Well, what we're doing now instead is we're actually saying to fee earners, okay, we've got to see some matter files from you. So we'll have an extended interview with you, maybe an hour. We'll ask you to show us on your screen, you host the screen sharing session, we'll ask you to show us your list of open matter files, we'll choose the matter files from that list, and we'll talk to you while you bring them up on your screen. I think you've got a question about that in more detail in a moment, Samantha, but that's how we're going to manage it. Where we're dealing with support staff, we may or may not need to conference in quite the same way. It could be done by telephone. But again, it would be this solution, the platform where the telephone screen sharing, it's down to the assessor to resolve this with you a few weeks ahead so that everybody's comfortable long before the assessment actually takes place.
Thank you. So you have discussed the possibility that staff may be furloughed. So this reduces the scoping, obviously, but where does this leave if whole departments might have been furloughed, or everybody in a certain role might have been furloughed? What will happen in that case?
Right, okay, so it is happening. I think most firms I deal with have furloughed to an extent already. That is true. To give you an example of how that may affect the scope, if your firm has 20 people and you furloughed 10, then the assessment will take place based on a scope of 10. So for this year and this year only, you'll find that if you fall into the right scoping category, you may find that you have just dropped down a notch on the scoping guidelines, which means your assessment might be fractionally cheaper because the assessor is going to see slightly fewer people and look at slightly fewer files. That will be judged on a case-by-case basis. Where furloughing takes place, if a whole department's been furloughed, and I have come across this with a conveyancing department in one firm, but if it happened to a family department, then the assessor's probably going to ask questions. Well, hang on a minute. Is that feasible? Is that correct? Do you have any matter files which are open? If it's a care matter or if it's a matter that's in court, can you actually put down tools completely and shut this whole department down? Maybe you can. If you think a whole department's going to be furloughed, or the assessor finds this out, they may want to discuss that with the Law Society and clarify that with you. In terms of what would happen if a whole strata of people are furloughed, so let's say, I've not come across this myself yet, but let's say every single secretary, paralegal and member of support staff has been furloughed during the time of the assessment. So essentially there's no admin support at all. It's not impossible, but it'd be unlikely. But what the assessor will probably do there is the assessor would want to know, okay, so you've done this, how are you managing the administrative functions of the firm or department if you've got no admin staff? What the assessor will do is probably speak with the practice manager in an interview, or with a managing partner or another partner, to get to the bottom of how risk and client care is being managed and business is being progressed in the light of the fact you've got no support staff at all. So again, the flexibility will come in there, and it's just around the assessor asking the right questions of the people who remain.
Thank you. So just going back slightly to fee earning staff and reviewing matter files, is there any flexibility on that? I'm thinking here if matter files are really, really large.
Okay, yes. I mean, I've seen matter files that were 12 sheets of paper thick. It was a will matter file that had been opened a week or two before and just got going. I've also seen matter files that were 10, 15, 20 lever arch files thick. Obviously, to go through, if we were talking about a normal scope for a normal assessment, what we would do is we'd look at matter files in advance, then interview the fee earner. And where there's a long matter file, yes, it can take a long time to go through it. And that's if we see it on site. If we're asking a fee earner to show us something on a screen, to bring up onto a screen 2, 3, 4, 500 documents would take hours, and it's just not feasible. What I've been doing so far is for each fee earner, I'm seeing 3 open and 1 or 2 closed matter files. And what I'll do is I'll say to the fee earner, okay, show me your list of files on your case management system, because let's face it, if a fee earner is working remotely, they've probably still got access to that case management system. And from that list, I am really choosing the files I want to see. And all those files, again, if they're 500-600 pages long, there is no time to look at all of them. But what I would do is I would look at the core documents. So I would say to the fee earner, please bring up onto your screen the risk assessment. Please bring up onto your screen a copy of any identification documents you've got, any evidence of the conflict of interest check, which of course must be there for a matter to commence. Show me the client care letter, show me any cost update letters, show me the terms of business. Let's have a look at any change of fee earner letters if that's happened. And of course, if people have been furloughed and some matters have been passed over, then yes, there will be a change of fee earner letter. Has there been a concern or a complaint? Has there been any invoicing? Have you instructed experts or counsel? So there will be some things that we can see documentary evidence of key milestones on the matter file, and we'll look at it that way. As an assessor, I'd also say, okay, thank you very much. Where are you with that matter? What is going on? At that stage, that may lead to further questions. Oh, this happened, so-and-so did this. Fine. Can you show me paper evidence of that, or electronic paper evidence of that? So that is how we would go about it. If a matter file is particularly long or complex, and it may be a 20 lever arch version of a file, then what we probably do is we can, rather than doing 3 per fee earner, we could do as few as 1. But there would have to be, if you like, special circumstances to do that. But we can do that too. Again, the flexibility comes in.
Perfect. In light of the current situation, are there any particular hot topics which the assessor is looking at more closely than perhaps during other years?
Yes, definitely. A few things that assessors are going to be asking about and wanting to dig into in more detail. Number 1, obviously, the business continuity arrangements. I know of one particular practice that's reflecting upon, not reviewing, but reflecting upon their business continuity plan twice a day. And that's how they've chosen to do it. Now, not all practices or departments had contagion or widespread sickness in their business continuity plans. I bet they do now. But what we're looking for as assessors is we're saying, okay, your business continuity arrangements, you've had your plan, how has that been working for you? What have you discovered that's worked or not worked? How has the implementation worked? How are you managing and sustaining the business or the practice or the department? We'll be drilling into things like supervision. So obviously file reviews are part and parcel of supervision, but they're not all of supervision. So how are talking to supervisors, how are you managing this? Where supervision is concerned, talking to other staff, talking to fee earners. How is your supervisor supervising you? Quite often it's by regular telephone calls with a supervisor or by email and other means, but how is that happening? How are file reviews happening? They may not happen as the same way as they have done previously. There may be restrictions on that, but a review of the substantive legal content of the work and the procedural content still needs to be done to some extent. Indeed, I'm sure insurers, because there will be claims arising out of what's going on during coronavirus, insurers are going to say, how have you maintained control on work? File reviews, good way of providing some evidence on that. Then there's things like AML and client due diligence checking. How are you managing that? The assessor is going to want to know, because the chances are you're not going to be able to see a client face to face for some time. Then there's staff access to documents and resources. How are staff doing that? Particularly if you've only got paper-based resources, how are staff able to access those if they're not in the office? Also, how are you ensuring client confidentiality? So the assessor is very likely to talk to support staff and fee earners and say, are you allowed to work with your family bringing you cups of tea in the background? What are you doing to maintain that? And how are you speaking with clients over the telephone or using conferencing if your family is buzzing around you in the same house? Little things like that. But very importantly, the assessor is very likely to ask you about your register of software that you use in the practice. 3.2 H of the Lexcel standard, to be precise. Lexcel's not asking you what software does the firm own, it's asking what software is being used to conduct the work of the practice. Now, if you sent staff to work at home and they're having to use their own devices, that therefore means the devices they are using to conduct the work of your practice. So the assessor is going to want to know, what devices are your staff using? What software have they got? And do you, the firm, know what software they're using? If they're using screen sharing software, you should know what software that is. None of your staff should be using Windows 7 at all. It is unsecure for doing any kind of work. So the assessors going to want to be sure, do you know what your staff are using to ensure client confidentiality? And that will come out of a discussion about your register of software being used by the practice.
Thank you. This question is dealing with corrective action. So are there any changes to the deadlines of corrective action? But also, what if there's non-compliances during the day? In a normal assessment, you may be able to resolve them on the day itself. So is there any kind of flexibility, or how will that work?
Okay, well, in terms of the deadlines for non-compliances, the 21 days and 90-day rule still applies, but there is significant flexibility in terms of how we can accept the corrective action. More than normal. For instance, majors and minors. A minor is something by definition that can be resolved within 21 days of the date of the assessment. A major is something that's going to take more than 21, but up to 90 days to resolve. That hasn't changed. An example of a minor might be, for instance, you've changed a policy, the person responsible for a policy, but you've forgotten to write in that policy document who's responsible for it. That would be a minor, and that is not going to take more than 21 days to resolve. That's definitely a minor. However, what I do say to practices, and I've always said this, irrespective of coronavirus and what's going on now, I've always said to practices, if you think you need more time to get it right, example, one practice a couple of years ago said, well, look, we need to resolve our business plan, but you know what? We want to get the partners together in our partners meeting next month. We're going to need more than 21 days. And I said, okay, no problem at all. Take that as a major. A major is a non-compliance, but a major is not the end of the earth. Similarly, though, obviously, firms can't say, and departments can't say, oh, well, we forgot to put somebody's name in a register. Can we have 90 days for that, please? No. you wouldn't be able to get away with that. But there is flexibility there in terms of how that could be done. Where it comes to corrective action, let's take a real example. 3.1E of the Lexcel standard says there will be regular data protection training. Regular means set a date, it means put a number on it. So what we were looking for there, let's say unfortunately you did all your training face-to-face and you were due to do your training on the 1st of May, and guess what, everyone's in lockdown, so you can't do that training. And there's no hope of doing training within the next 90 days. You simply can't get everybody together to do that. Now, that's a bit of a problem because you can't do it within 90 days. You're not going to be able to get the evidence because everyone's locked down. What we might say there is make that a non-compliance where you will write to the assessor to certify to the assessor, we promise we will do the training with all the staff when everyone's back on the, 1st of October. And you will also send the assessor additional evidence of perhaps the training plans for all the staff. Having made that promise, we're not going to go back to you in October the 1st and say, right, show me the records. That's 6 months away. We're not going to do that. But what we are going to do is in the 2021 assessment visit, we will be expecting to see evidence that the training did take place as you promised on the 1st of October or thereabouts. If you didn't do it and it still hasn't been done, that could constitute a major non-compliance. So that's how we're going to approach it flexibly. But bear in mind, we will be checking up on all these things in 2021.
Thank you. I think you mentioned this at the beginning, but just to double check, it is an option to postpone the assessment, did you say, and it wouldn't break the accreditation?
That's right. There is an option to postpone the assessment. There are certain controls around there. First and foremost, if you think you might need to postpone, speak to your assessor first. That's the most important thing, and the assessor can guide you through it. If you decide a postponement is going to be necessary and appropriate, you need to agree an alternative date with the assessor, and then you need to write to the Law Society to ask for their approval to do so. I would suggest you copy the assessor on the email so they can track it with you. Now, at the moment, departments are allowed to postpone up to the end of July 2020. So, for instance, let's say your Lexcel anniversary month is May. Now, normally that means you've got to come forward for assessment in April, May, or June. But you decide, do you know what, we're not going to be out of lockdown till at least the end of June, probably. So we'd like to postpone our assessment until the 30th of July, and that's fine, but you'd need to agree that with the assessor. It is on a case-by-case basis, but that is possible, and it can be done that way.
Thank you. So obviously we hope that nobody becomes unwell, but what happens if the assessor themselves becomes unavailable due to sickness or furlough leave themselves?
Well, we hope none of that ever happens, but we can't rule it out. The Law Society and the assessment units have been adamant from the start that this scenario should not disadvantage a law firm. You would have a new assessor appointed to you. The assessor would let the assessment unit know, and the assessment unit would appoint a different assessor to take over for this year. Generally speaking, what would then happen is your normal assessor would then come back and take over for you next year. So you don't need to worry about it. You will get your assessment on time, especially if perhaps you've got a publicly funded contract that depends on it. And actually, I should just add to that, I didn't completely answer a question you asked about postponement. Where postponement takes place, if you are postponing to much later in the year, maybe 2 or 3 months beyond your normal anniversary for Lexcel, don't worry, your Lexcel accreditation won't expire and it will continue and sustain until you have your assessment.
Perfect. So I think that's all of my questions asked, Neil. Do you have anything to add?
Loads to add, but I'm always there on the phone if somebody's got a question. I would say to anybody, please do get in touch with your assessor directly if you have any queries or concerns. They have been well informed to help. I think what I would add at this point, Samantha, is that we have got more podcasts plus like this designed to help. One of them is coping strategies for law firms during the COVID-19 emergency, where we've actually interviewed a managing partner of a multidisciplinary firm who's coped with it very, very well, and some of the lessons learned from that, which we'd like to share with you through a podcast. So please do look in on us. Please do go to the website, and by all means, they're free. Grab yourself one of these podcasts. But again, thank you very much, Samantha, for asking me the questions today.
Yeah, thank you very much.